Defamation is something that hits pretty close to home. I have been involved in more than 20 different lawsuits as an expert witness in defamation cases, and they come in all shapes and sizes. It's something that you need to know something about. So I always like to start off with this quote from Othello, which is from Act 3, Scene 1. Who steals my purse steals trash. 'Tis something, nothing. 'Twas mine. 'Tis his, and has been slave to thousand. But he that filches from me my good name robs me of that which not enriches him and makes me poor indeed. That's what libel is all about and how important it is. There are a number of definitions, but none are really precise. Libel is a state law in all of the states. There are times when it can be tried in federal court, primarily if the two parties are in different states, but then there's a determination of which state law applies. Bruce Evanson, in The Responsible Reporter, says that defamation is a communication that exposes a person to hatred, ridicule, or contempt, and lowers him in the esteem of his fellows, causes him to be shunned, or injures him in his business or calling. The Associated Press Style Book warns that probably 95 out of 100 libel lawsuits arise out of run-of-the-mill stories, not the big ones, but the little ones. And most of the lawsuits are actually caused by carelessness. And that's actually been my experience in terms of the work that I've done. There's called libel per quod. You're not going to run into this a great deal. They're libels that are not readily apparent. They're only libelous because of the context or circumstances. So he is perfectly healthy is fine. It's not libelous unless it's said about a person collecting disability benefits and suspected of defrauding his insurance company. Then the possibility of libel exists. A wedding announcement would not ordinarily be defamatory unless it was printed after being called in as a practical joke on two people who hate each other. A mention of her pregnancy would not be defamatory unless the facts are that she is a nun. That's not disclosed. Most of what you're dealing with is what is called libel per se. It applies to statements that are defamatory on their face and could damage the reputation of a person. So that charges or claims that a person has committed a crime and did not. In fact, I ran into this in one of the cases that I was dealing with, where a newspaper claimed that a woman was an accessory after the fact to a murder. Well, in fact, it was her daughter, and the newspaper refused to write a retraction and lost a significant amount of money because it refused to do that. And writing a correction does not necessarily mean that you are going to get away with the libel, but it is seen as a way of mitigating the libel. Statements that disparage a person's competence in his or her business can be libelous. Statements asserting or implying that a person has a contagious or offensive disease can be libelous. And charges or claims concerning an individual's personal habits or character, especially sexual immorality, can be libelous as well. There are several standards that need to be met in terms of a libel case, which is, by the way, a civil case, a tort action. First of all, it has to be demonstrated that it was published, so that it needs to be published or broadcast in a manner that at least one person other than the plaintiff and the defendant reads or hear it. Identification. The libel must be of and concerning the plaintiff. Plaintiffs must be able to prove that other people recognize them by name or description. And it doesn't necessarily have to be the name. I'm involved in a libel case right now where a business was attacked, and it was well known who the owner of the business was. So he's suing that his reputation was damaged because of the manner in which his business was named. Defamation, more than simply carrying false information, the statement must carry some kind of sting that would damage a person's reputation, hurt his or her business, or cause his or her friends and associates to shun him or her. So, for example, if you made a mistake and said that, I'm 59 rather than 60, it's inaccurate, but it doesn't damage my reputation. There has to be a demonstration of damage, injury, or harm. So the plaintiffs cannot prove actual malice, who they must show that they suffered some kind of damage, such as personal humiliation, mental anguish, or actual financial loss. The types of damages that can be assessed in a libel case are actual or special damages, those that can be calculated in a rather precise way, that I lost money, I lost wages, and these are fairly easy to prove. There are general damages which are provable but not intangible. That is shame, humiliation, loss of good name, and mental stress. And then there are punitive damages, and this is where the big money comes in, where plaintiffs who can show actual malice may sue for punitive damages that go beyond compensating the plaintiff for the actual injury. And they're intended to publish the defendant, the news organization, for the libel. That's the big money. Fault. In most cases, the plaintiff must prove some degree of fault on the part of the defendant. So the plaintiff being me, I say I've been libeled, the defendant, the news organization. So I have to demonstrate as the plaintiff that the defendant has acted in a careless or irresponsible manner that resulted in the injury. There are a lot of ways to do this. So for example, if there's a policy that says that all unnamed sources or confidential sources must be approved by the managing editor before they go into a newspaper story, and that didn't happen, that's careless, and that can go a long way to proving libel. For public officials and public figures, there has to be shown actual malice, and those are based on Supreme Court decisions, and that means that I actually went after the public official as a reporter. In fact, I was involved with a case in Pennsylvania where a sheriff claimed that a specific television reporter was out to get him, and the jury agreed that the television reporter was out to get him, and gave him a judgment of about $450,000. For private persons, it's different. The reason that it's a higher standard for public officials and public figures is that they can generally call a news conference and say, well, here's what I did, here's my statement, but for private persons it's much more difficult. So that for private persons it actually involves matters of public concern. So what are my defenses? Well, first of all, I can prove that it's true. If I can substantiate that my report was true, I'm an automatic winner. I can also say that it's fair comment and criticism if it comes to a column. So that if I am doing a review of a play and I think it's terrible, and I think that the actor is terrible, and I write that, then it's fair comment and criticism. There also is a defense that it's a fair report or under reporter's privilege. And we'll talk a little bit about this when we get to the issue of confidential sources, is that in most states, what reporters have is qualified privilege rather than absolute privilege. Absolute privilege goes to people like doctors, lawyers, clergy, right? but we have qualified privilege. For example, we can cover a debate in a state legislature, and Fred Smith, the senator from Philadelphia, may call Sam Smith, the state legislature from Pittsburgh, a crook because he's not willing to give people their fair share of their money. I have qualified privilege to use that because it's in the context of a legislative debate. The same goes for a trial. If I'm covering a trial and somebody says Chris Harper is a murderer, and I quote that, I have qualified privilege because that's part of a trial. There's also a constitutional defense, which gets into that I did not specifically go after the public official, that there was an absence of malice. And sometimes it's simple ignorance as well, that I was unaware of what in fact was wrong with the story. There are technical defenses. One is that there was consent to do the story, and then someone, pulled back after telling me a variety of items about themselves. There's a statute of limitations. It varies from state to state, but I think it's fair to say that about 1 to 2 years is when a libel case has to be submitted to the court for consideration. It's not 7 years as it is in most criminal proceedings, or in the case of a murder, there's no statute of limitations in many states. A retraction or correction is not actually a defense, but it might serve to mitigate damages. Mistakes are going to be made in news organizations. It's called the first rough draft of history, and sometimes because of the speed involved in reporting things, mistakes are going to be made. And they may not be libelous. They may not have been intended to be libelous. They simply are errors. So there's some important cases, and I'm not going to spend a lot of time on these because they're covered to a great extent in the book. The big one is the New York Times v. Sullivan in 1964, where the New York Times was sued for libel by an Alabama state police commissioner. It was actually in an advertisement in the New York Times. Alabama didn't necessarily like the New York Times back then. It went through the court system, and in the Alabama court system up to the Supreme Court. The official won the case, was actually given $50,000 in damages, which was a lot of money back then. It went to the U.S. Supreme Court, and the justices there said that if news organizations cannot have a higher standard when it comes to public officials, it would significantly limit the debate about what's going on with public monies within government, and so therefore they placed the bar higher with what is called actual malice, that I intended as the reporter to go after someone and did it maliciously and recklessly disregarded facts that I knew. Now, Curtis Publishing v. Butts extended it to public figures like movie stars, sports figures, that, and essentially what it means is that, as a sports figure like Kareem Abdul-Jabbar, for example, that I can call a news conference, I can fight back at the people who are saying bad things about me, and so therefore it extended that actual malice and reckless disregard of the facts to public figures as well. And Herbert v. Lando involves a 60 Minutes producer. It went to the issue of what was the state of mind of the producer, in this case Barry Lando of 60 Minutes, when he was doing a story. So, as I say, the book covers these in great detail, but fair warning, there are more libel cases out there, and it's something that you have to be concerned about. It doesn't mean that you hold back, but you need to be aware of what the standards are and what you need to do.